In each of these matters, Mr. Trout is here today after failing to appear before referee Jordan on August 9th, 2021. In the first case, bond is currently set at $500. This is the second bench warrant. In the second case, bond is currently $839, and this is the third bench warrant. Front of the court is unaware of any employment information. The last payment made on these accounts was in May of 2021. Front of the court recommends that reasonable bonds be set in each of these matters, and they be scheduled for hearing on June 7th, 2023 at 8:45 a.m. before this court.
Mr. Trout, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on June 7, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Actually, Your Honor, I can on Friday. I started the job on the 15th. I get my first check this Friday.
Okay. Well, you do have 2 bench warrants in one case and 3 in another, but obviously what I'm going to do is I am going to reduce your bonds in hopes that you would be able to be released pending that hearing. I'm going to set your bond in each case in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
Your Honor, if I don't make it to work tonight, I get fired, then I can't pay anything. If I miss one day in my first 30 days, this is my first job I've had in 5 years.
Okay, well, I'd like to help you more than that, other than the fact that it's been well over 2 years since you've paid anything. So I'm taking that into consideration, the fact that you didn't appear at that particular point. So maybe you can contact somebody and get them to post the bond for you, and you'll be able to get out. So that's what we'll do at this
Mr.
point.
White
So
is here today
will end
after
this
failing
matter
to
at
appear before this
8:35
court
a.m.
on October 5th, 2022. Bond is currently set at $1,977. This is the second bench warrant. Front of the court does not have any employment information at this time. Last payment made on this account was in April of 2023. Front of the court recommends that a reasonable bond be set in this matter, and it be scheduled for hearing on June 7th, 2023 at 8:45 a.m. before this court.
Okay. Mr. White, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond so that it assures your attendance at the next hearing on June 7, 2023 at 8:45 a.m. Are you able to post a bond, sir?
Yes, I would like to say something. This is my second time being in jail for this, and I do have work, and I have work at 4 today, and that child support is very high for one child, and I never had it switched and set and lowered down because I talked to like DHS, and I don't really know how to do that because I'm really new to this stuff, and they said I can get it lowered or whatever, because every time they take 130 out my check and I get paid every week. And that's what, 425 a month for one kid.
Okay. Well, it's based upon your income. It's not based upon 1 or 2 kids. I mean, that does come into play. What you're going to have to do is, if you want to change it, you're going to have to file a petition to modify your support and set forth the factual basis for doing that. And the court would have a hearing and then modify it if it's appropriate. So all you have to do is file a motion. You can get that at the clerk's office, and you can file it yourself.
Okay.
Are you able to post a bond, sir?
Yeah, I'm trying to at least get out for work today, because this is the one that's really holding me up. I got like a traffic stop ticket, but that's nothing. But I do want to go to work today.
Okay. Well, the court notes that your last payment was in April. Why have you not paid since that time?
Because I have a new job. And I get paid this week on Thursday, but I can't pay nothing that I don't got right now. I mean, I can bond out and make bail today or whatever if you let me, but I get paid on Thursday, which the court's going, whatever, they take it out my check or whatever.
Okay, that's the question. Is you say you can bond out, you're going to have to pay something to bond out, though.
Yeah.
What are you able to post as far as a bond?
I mean, I can pay 100 today and I can give some more on Thursday. Like,
Well, it is your second bench warrant, but you paid recently in April. So the court's going to set your bond in the amount of $100 that allow you to get out. I would suggest that you make some additional payments on this matter before we come back for the hearing on June 7th, as that will help your case. And then also that you would file your motion to modify, okay?
yes.
Okay.
Yes, I have
Court
to
will,
do that.
court will conclude this matter at 8:40
Each of
a.m. You're
these
free to go.
matters,
Have a
Mr.
good day.
Person is here today after failing to appear before this court on September 28th, 2022. In the first case, bond is currently set at $2,749. This is the seventh bench warrant. In the second case, bond is currently $868, and this is the second bench warrant. Front of the court does not have any employment information at this time. Last payment made on these accounts was in April of 2023. Front of the court recommends that reasonable bonds be set in each of these matters, and they be scheduled for hearing on June 7th, 2023 at 8:00 a.m. before this court.
Okay, thank you. Mr. Person, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 7, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
My girlfriend just miscarried our unborn child, and literally I just put all my money towards that. I've been on the right track. When this lady said my last payment was April. I mean, I hope this isn't too much to ask, but if I could get PR on this so that I can get back to work, I do work. I have my own business. I've recently just started working at Jerry's tree service. So it's like the quicker I can get out, the quicker I can get to work and continue on. You know what I'm saying? What's going on? And like I said, tonight, I just scheduled my DNC with my girlfriend because she did just miscarry her unborn child.
Okay.
But she has three children of her own, and that'd be something that I really need to be there for. You know, I'm not a runner. You know, I just had a really bad string of luck, and I mean, I apologize to the courts, but like I said, if that's something that I could request from you, if that's something I'd like to bring up, I just put all of my money into making sure that she was okay emotionally and physically. A miscarriage of a woman is that's a lot to deal with on them.
Well, I understand that, sir, but the fact is the court is here to collect support on the other child or children that you have. And
yeah, that's what I'm saying.
Your last payment was in April. Why haven't you paid since then?
Because I haven't said just because he said it just got started. We were just getting established of like finding this new apartment and getting a car. I like I said, I can definitely put money and I definitely will be there. I care about Zoe a lot. You know, like I said, if I'm lacking on payments, I can definitely make it to court. Especially now since we have the whole Zoom thing going on and whatnot. The only reason why I missed court and whatnot is just because it was bad schedule. It was a very horrible time. I even tried to reschedule it and everything else around it. I can definitely be there. That's not a problem.
Okay, well,
I'm just asking for, you know what I'm saying? I'm pretty much begging, you know.
I understand. Well, what I'm going to do is I'm probably against my better judgment. I'm going to set your bond at 0 in each case that allow you to get out to get to work. But
Yes,
I will tell you, by the time we get into that hearing on June 7th, which is only about a week away, a little over a week away, I better have seen some payments on this matter or payment. If I don't, I'm going to take that into consideration as to whether you go to jail. You understand?
Yes, sir.
Okay. Court will conclude this matter at 8:44. You're free to go.
Parker is here today after failing to appear before referee Delmont on February 27th, 2020. Bond is currently set at $3,267. This is the fifth bench warrant. Front of the court does not have any employment information currently. The last payment made on this account was in October of 2019. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 7th, 2023 at 8:00 a.m. before this court.
Mr. Parker, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 7, 2023 at 8:00 a.m. Are you able to post a bond, sir?
If it was reasonable, yeah, you know, like $200 or $300.
Okay, well, you've got a sizable arrearage. I mean, the bond currently is set at just below $3,300, and you haven't paid in almost 4 years. So
I had a lot. My mom's died, COVID. I've had a lot going on.
Well, everybody has a lot going on, but that doesn't mean you can't pay support.
I understand, sir. I haven't been in this situation in 10 years. I just, if I can get out, I can start making payments. I just need a reasonable bond and I can make them. I won't miss them. I won't miss a payment.
Yeah. Well, you've obviously missed a lot of payments. So
I understand that, but I've had a lot going on, but I don't want to be in this situation. I haven't been in jail in a long time. I just need to get my orders together and I'll make my payments and I don't want to be back here.
okay. Well, what I'm going to do is I am going to reduce your bond in hopes that you can be released. I'm going to set your bond in the amount of $500. And I will tell you, if when we get back on the June 7th, if you haven't made any payments in this matter, the court is going to consider that as to whether you go to jail or not.
Okay, so that $500 that I bond out with,
Yes.
can I apply that to my payments?
No, that's for your bond for your appearance.
Okay, so $500 I can get bonded out now?
Correct.
Okay,
Court will end this matter at 8:47 a.m. You're free to go.
Today, after failing
Thank
to
you.
appear before referee Croteau on June 30th, 2022. Bond is currently set at $3,787. This is the first bench warrant. Front of the court does not have any employment information currently. Last payment made on this account was in September of 2021. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 7th, 2023 at 8:00 a.m. before this court.
Mr. Seeley, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 6th, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, not at all right now, sir. Just to clarify with the court, I did know I had this warrant just recently. I got in contact with law enforcement. They told me advise and release. I tried to come in front of I should have came here and turned myself in. I'm sorry I did not, but this is a crucial time for me because I'm starting employment through Martin Rhea. I filled out the paperwork for the front of the court this morning. Today was supposed to be my orientation, but every Thursday we have a job fair. I'm gonna be making gas line and brake line in Manchester. I've been living in the homeless shelter in Jackson at the Interfaith Shelter, sir. I've been having a very hard time. I want to get out and succeed, do better, but that's what I need to do. I got to get out of jail and go to the job fair again this Thursday because they drive me to and from work for $40 a week out of my check. They got me hired in, and then, like I said, today was supposed to be my technical orientation, but I know they'll let me back in. If you could please give me a break, sir. I'm not trying to run from this. I will be back to court. I will pay anything I need to. I need to take care of this matter. I'm relieved that I have been arrested and that I am going through this process right now. I want to say that I am relieved that I'm taking care of this matter, but I'm begging you, if you could let me out on a zero bond today, I will appear. I didn't know I had to appear before when I was served, Your Honor, and I'm very sorry to this court.
Okay. Well, you've got a sizable arrearage and you haven't paid in almost 2 years.
I've been homeless, sir, and I'm so sorry. I'm sorry.
Okay.
I'm not trying to cut you off. I've been homeless. I've been struggling. I have an injury to my hand and I had surgery on. But if you could please take consideration into my case, I don't know. I had a lot of problems with the child's mother. I was a good father for 8 years. I did buy the house that they live in. She put a PPO on me, so I had to leave the area. I went up north, and that's what happened. I was living in Clear County, Your Honor. Then I came back down, was living in Jackson County, homeless on the street. Like I said, I'm a resident at the Interfaith Shelter right now. And I just got into the job fair with Martin Rhea, and that's what's going to help me pay. I'm just going to start working again, Your Honor.
Okay.
So if you could please, I'm begging you.
Well, it's your first bench warrant, so the court's taking that into consideration.
Okay,
But
thank you.
you have a sizable arrearage,
Yes,
so I'm taking
I
that into
understand.
consideration as well. What I'm going to do is I'm going to reduce your bond substantially, but I can't set a cash bond. I'm going to set your bond in the amount of $300. If
I'll
you're
still
able
be
to
a
post
judge.
that, if you're able to
I
post
can't.
it, you'd be able to be released. Do you have any
I
questions?
can't post it.
Okay.
Please, Your Honor, I can't post it. Can you please give me a zero bond?
No, I'm not
please.
going to give you a zero bond, sir. So,
Okay, I'll be here until when?
June 7th.
June 7th?
Yes.
I thought it was the 6th.
June
Please, Your Honor.
7th. June
Please.
7th.
Please, can you please
Court-
give me a zero bond?
Is
No, I won't,
today
sir.
after
Thank you.
failing to
Okay.
appear before this court on September 9th, 2020. Bond is currently set at $7,562. This is the fifth bench warrant. Front of the court does not have any current employment information. The last payment made on this account was in September of 2020. And for the record, that was a $1,500 bond forfeiture. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 7th, 2023 at 8:45 a.m. before this court.
Mr. Dolly, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing. As a result of your failure to pay child support, the purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 7, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir. I mean, how much would the bond be? I mean, I haven't worked hard in 3-4 years.
Okay.
Do a disabled back, so I just don't know, sir.
No. Well, what the court's going to do is I am going to reduce your bond in hopes that you'd be able to be released. I'm going to set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you.
When could I be released, sir? As soon as I post the bond or?
When you post the bond, sir, yep.
Okay, thank you.
Thank you. Court will end this matter at 8:54 a.m. You're free to go. Okay, good morning to all of you. Ms. Terranova, I know you have a motion. I'm going to take some proofs first. We can just simply preserve those and then we'll go into your motion. Thank you. Ms. McNiff, you can proceed.
Thank you. Ms. Rupel, do you remember coming to my office and signing a complaint for divorce?
Yes,
And when you signed that complaint for divorce, were all of the allegations in it true?
yes,
To the best of your knowledge, are they still true?
yes,
Are you currently pregnant?
no,
Did you live in Calhoun County for at least 10 days in the state of Michigan for at least 180 days before we filed that complaint for divorce?
yes,
And has there been a breakdown of your marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yeah.
May it please the court.
Court is satisfied that the testimony does establish the statutory basis. The court will find that there has been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending further proceedings. Ms. Terranova, you can proceed with your motion.
Thank you, Your Honor. I filed a motion to set aside the default, which I'm presuming the court read my motion.
I have read it.
I'm sorry.
I have read it. Yes.
Yes, I presume so, Your Honor. I know you're always prepared. The defendant in this matter was unrepresented through the majority of the proceedings, Your Honor, and I would note that he did appear for status conferences and such that was held before this court. So it wasn't a matter as if he completely ignored notices or didn't appear, Your Honor. There has been a proposed judgment that has been provided by Ms. McNiff. Your Honor, I believe there is good cause to set aside the default. As I've stated, my client did appear by himself and represented himself during this matter. There were periods of time that the parties were living together and in fact attempted reconciliation efforts. I did reach out to Ms. McNiff while I was on vacation, actually, in March to let her know that I was going to be representing Mr. Rupel. And it is correct. When I went to file my motion, I realized that an official appearance had not been filed, Your Honor. But I had reached out to Ms. McNiff and let her know that I was going to be representing Mr. Rupel. And it was indicated that there was going to be a trial set for June, or that there was a trial set for June 13th. So, Your Honor, divorce actions are equitable in nature, and divorce settlements are supposed to be fair and equitable. And I'm concerned that the proposed judgment of divorce is not fair and equitable under the circumstances, Your Honor. Additionally, I believe that the custody and parenting time that was set before this court was done on a motion on a Monday motion morning where oral arguments were made. So I think there would need to be a finding as to the best interest factors regarding the minor children as to custody and parenting time. We are still under the 1 year mark, Your Honor, that the stale deadline that I know the courts like to stick to. So I believe there still would be sufficient time to finish this case, Your Honor. So I'm asking that the default be set aside, that Mr. Rupel be entitled to file a answer, and I can have that prepared in 7 days. Quite frankly, Your Honor, I could have it sooner if the court required. But I don't think there'd be any prejudice to either party. And in fact, I think this would allow for a fair and equitable judgment to order. Thank you, Your Honor.
Thank you. Ms. McNiff, do you have anything in addition to your answer in this matter?
No, Your Honor.
Okay. Well, in this matter, the court will note that Mr. Rupel was involved in proceedings previously, did not file an answer, did not seek counsel. The court will find that there is not good cause to set aside the default. But as Ms. Terranova states, it is equitable in nature. The court does want the parties to be, again, having a say-so and involvement in it. What the court will do is allow the defendant to participate in, again, disputed issues, mediation, et cetera. So the court will order the matter to mediation, which means the court will have to adjourn the trial. So I will adjourn the trial and we'll set a new date following mediation. I'll ask Ms. Terranova, who would you recommend as a mediator in this matter?
Your Honor, in the past, when I've had a Calhoun County, I've used Mr. Brundridge before.
Okay. Okay. Ms. McNiff, is Mr. Brundage acceptable as a mediator?
He is, Your Honor, although I believe he's scheduling into August at this point.
Okay. Well, what the court will do is, that'll give you some time to get things, basically give you, boy, that's a long time.
Well, it is, Your Honor. And the other issue is, of course, we haven't done any discovery. I mean, I've done some discovery in terms of sending subpoenas, but the house hasn't been appraised. My understanding is Mr. Rupel has a new job.
Okay, let's do this. Well, the court will set, I'm gonna have Ms. Terranova, I'm gonna have you do the order in this matter. So I'll have you do the order that the court will not set aside the default, but will allow your client to participate in disputed matters, which would, the court will order the matter to mediation with Mr. Brundage as soon as he can get it scheduled. Court will give you until July 1 to accomplish any discovery. I'm putting you on a short date because I note the court it's 287 days old at this point. And what we'll do is Mr. Brundage can get you in sometime, and hopefully he can get you in before August, but if not, the court will set this matter for a settlement conference sometime in later August in this particular case. So Ms. Terranova, if you would prepare that order, you can submit under 7-day notice, and hopefully the two of you can proceed and get this matter before Mr. Brundage or get it resolved otherwise. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
Court will end this matter at 9:07 a.m. You're free to go.
Thank you.
Maybe show me on the connect here. We have some. Oh.
Court will note the appearance of, guess we don't. Oh, I'm sorry, I'm on the wrong file. Sorry. Ms. Shadowins on behalf of the plaintiff, Mr. Toth on behalf of the defendant. We had two motions scheduled for today. However, the first motion as it relates to the appointment of GAL was resolved. The parties did sign a stipulation, which the court entered in this matter. So the only matter before the court today is the defendant's motion to adjourn the trial dates. Mr. Toth, obviously we have a lot of property issues in this particular matter. Why can't we proceed with the trial and address property first and then move on to issue of the children once the GAL is in place, et cetera?
Your Honor, I would, there's a couple of reasons. One of those, Your Honor, is with the subpoenas that have gone out by both parties, the third and fourth dates of trial in this case, there's probably 15 witnesses who have been subpoenaed that all relate to the child-related issues. There's police officers, therapists, Dr. Haugen, 2 counselors, school teachers. So basically what we're going to end up happening is we're going to have a couple of days where we can do property, and then with everybody who's been subpoenaed to start appearing on the third and fourth dates, it's going to be shifting gears and then shifting gears back, which it's difficult enough to keep track where we are. That kind of format, I think, Your Honor, would not do a service to the parties and certainly not to the minor child. That would be number one. Number two, Your Honor, is this case has been going on forever. We have 7 or 8 confirmed trial dates. What has manifested itself just very, very recently is an allegation of sexual misconduct. The child has been subjected to a CIT by Branch County. My client's been advised by the investigator that the investigation is complete and they're simply waiting for production of the order. Your Honor, I think we need to know how that's going to have a dramatic impact on this case one way or the other. Absolutely. It's not a secret, at least from where I'm coming from, is that in a divorce case where you have child-related issues and property-related issues, oftentimes a global settlement is the only way you're going to be able to settle the case. My belief, at least from my perspective, is the results of this CPS investigation are going to have a dramatic impact on my assessment of the issue, and I'm certain will impact my client's assessment of the issue. So we should know what we're facing here, Your Honor. Again, there's no more serious allegations that can be made than have recently occurred, and I think it's important to know to have that information before we proceed into a trial. And again, just looking at the schedule to bounce from one area to the other and then back, I think it's logistically, it's going to create a very, very difficult situation.
Okay, thank you. Ms. Shadowins, I've reviewed your answer, obviously. Anything else you'd like to add?
Well, I think that when you're trying a case of this magnitude and this length, your witnesses are going to almost always have to be flexible. And because we don't truly know how long this is going to take until we kind of get into it. And, you know, we would be proceeding with plaintiff's case in chief anyway. And I can tell the court that I believe that the first 2 to 3 days of my case in chief would be property related. And so I don't really understand why we would essentially give up 2 full days of precious court time for that. Subpoenas can be reissued, witnesses can be called, and times adjusted. We do that whenever we try a case. So, I mean, I think that Mr. Toth is right. If we had the reports back from CPS, or if the investigation had concluded, we might be able to exchange some type of more detailed negotiations. But I have reached out to CPS, I've reached out to the detectives, and I really haven't, you know, received any response as to where they're at in the investigation. So, I mean, we can only go with what information we have. I guess it's the court's choice where how the court wants to proceed. I know that, you know, court time can be very precious, and so I know that I'm ready to proceed on the property issues on June 6th. And then, you know, where we go from there, I guess, will be based upon the results of the investigation.
Okay, thank you. Well, what the court's going to do in this matter, and I obviously based upon what the attorneys have said, is obviously the issue with the CPS investigation, and that has obviously put substantial, I guess you say, difficulty in this particular case. The court does note that that does need to get resolved prior to proceeding, at least as it relates to the child issues. And as Mr. Toth states, that could have ramifications for settlement and other, you know, the other issues as well. It may be, it may not. I am loath to change and eliminate the, you know, the trial dates we have, because as stated, it's hard to get those. And but it does appear in this case that this may be one of those cases in which we have to. What I'm going to do is I am going to grant the motion for adjournment. We will be in touch with your offices either today or tomorrow and see about maybe we can keep some of the last dates that we have and then just simply move, let's say, the first 2 or 4 dates, and maybe we can get the other matters, you know, started at least at that particular point. So that's what we'll try to do, is keep as many of the dates as we can and move the first few. And then I guess we'll just wait on DHHS to get this matter concluded, and then we'll proceed from there.
Thank you, Your Honor. I'll prepare an order.
Okay, thank you. We'll be in touch with your offices. On behalf of the plaintiff, Ms. Podolsky, on behalf of the defendant, this is a defendant's second motion to modify judgment of divorce relating to custody, support, parenting time, and other relief. Ms. Podolsky.
Thank you, Your Honor. The parties were here in the summer of 2022 on their first motion regarding this modification. An evidentiary hearing was held and an order entered on October 18th, 2022. That order provided to the plaintiff mother the sole physical custody of the minor child, and father was to receive parenting time the first full weekend of every month, Christmas Eve in certain years, Christmas Day in certain years, one half of the Christmas break, and then 2 non-consecutive weeks during the summer. Since the entry of that order, the father of this minor child, who's now 15 years old, has not seen her once. He has not exercised any of the ordered parenting time. He has not contacted the minor child. He has not contacted the mother of the minor child. He did not exercise any parenting time on Christmas. He did not contact the minor child on Christmas. He did not exercise parenting time on her birthday, nor did he contact her on her birthday. He was to contact plaintiff by May 1st of 2023 to choose his 2 non-consecutive weeks for summer parenting time, and he has failed to contact her. Not only has he not had parenting time since we were in court back in September and this order entered, he has not had any contact with the minor child since July of 2022. The minor child testified at that hearing. She expressed a preference to the court. She explained her positions and her feelings on parenting time and the lack of contact that she was having with defendant. And unfortunately, the defendant just continues to not exercise parenting time. Further, these parties were ordered to use Our Family Wizard to communicate. My client has reached out to the defendant father regarding an issue with braces that the minor child needs. His response was, we can revisit this topic in July, putting the issue off for several months, even though this is a recommendation of medical need as outlined in our motion. Further, the parties do have a child support order that provides a split of the out-of-pocket medical expense. My client has paid her portion of the required out-of-pocket medical expense. Defendant is now required to pay his percentage. When she sent a payment request via Our Family Wizard, their communication app, he used the option deny to deny that request. In his response to this motion, the defendant alleges that he wants to have a relationship with the minor child, that he wants counseling, that he's been waiting for counseling to start. However, counseling was not ordered after that hearing. It is not in the court order. He has made no attempts to initiate counseling. He has not contacted the minor child to do so. He has not contacted plaintiff to do so, nor has he motioned this court to ask for counseling between himself and the minor child. We believe that his requests to rebuild this relationship and for counseling are disingenuous at best. We think his actions speak louder than words here. Again, it has been now almost a year without contact between defendant and the minor child, and we're asking the court to set parenting time as the parties agree and order sole legal custody to the plaintiff mother so she can move forward with these necessary dental decisions for the minor child.
Okay. Ms. Podolsky, as Mr. Vanderhorst put in his answer that, and as you've acknowledged that he stating that that he wants counseling, is there any problem with the counseling with the child?
At this point, it has not been discussed with the minor child, but it has been over a year since he's had contact with her. He is no longer living in the county. He's 2.5 hours away. So this would have to be some sort of virtual counseling, or he would need to make the effort to come here to Calhoun County. The minor child's in high school. She has activities and volunteer opportunities that she's participating in. And I think that it would likely be a long road based on the testimony she provided last summer and now continued several months of no contact from her father.
Okay. Mr. Vanderhorst.
Thank you, Your Honor. There has been a period of time that the plaintiff has not seen the minor child. The plaintiff does want to continue to have a relationship with the child, would like him and the child to attend counseling to work on any issues between them. The issue of braces, the plaintiff was willing to address the issue this July. He was willing to discuss it this July, basically based on he was financially ready to proceed with paying for the braces and helping defendant with the cost of those. Plaintiff is willing to communicate with the defendant about the issues of braces and any other health-related issues regarding the minor child. The plaintiff is respecting the minor child's wishes and has not been exercising his parenting time. This is not due to him wanting to maintain a relationship with the child, but him realizing that he and the minor child may have to work through some issues for him to have parenting time to resume. Plaintiff does want to be a part of the child's life and does not want to lose his relationship with her. Plaintiff is willing to attend counseling and is asking that he and the minor child attend counseling to strengthen the bond between them. Plaintiff is requesting that the defendant's motion be denied and the order entered on October 18 of 2022 to remain in place, with the exception that the parties are ordered to, or the plaintiff and the minor child are ordered to attend counseling. Thank you, Your Honor.
Okay, thank you. Well, what the court is going to do is the court does find that there is a sufficient proper cause change in circumstances pursuant to the Varka threshold sufficient to get an evidentiary hearing. So the court will order that evidentiary hearing in this matter. The court will, in the interim time as well, will provide and allow for some sort of counseling as the plaintiff states he desires to have. I don't know if he will or won't. The court, however, in view of, again, the child's age, involvement in different things, court is going to order that that counseling would take place in Calhoun County, that the parties would agree upon a counselor, and that, in fact, the plaintiff would be responsible for the cost of that particular counseling. And then we'll proceed and we'll be in touch with your offices to get some dates on which you're available. But obviously, the court would want some counseling to take place before we have the evidentiary hearing. So I guess I'll leave that up to Ms. Podolsky. If you would, when the counseling is set up and the counseling is taking place, let us know, and at that time we'll set a evidentiary hearing date. They'll give us maybe 60 to 90 days down the line. We can maybe get some input from the counselor. The court would order that the counselor would file a report with the court as soon as the counselor is able to do so. Anything else, Ms. Podolsky?
Nothing. Thank you.
Okay. Mr. Vanderhorst?
Nothing further, Your Honor. Thank you.
Okay. Ms. Podolsky, I'll ask that you
Court will
would prepare that order.
Mr. Vanderhorst on behalf of the plaintiff, Ms. Capture on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, support, and parenting time. Mr. Vanderhorst.
Thank you, Your Honor. Parties were married on October 26, 2018 and have one minor child, Theo, age 1. Plaintiff lives in Albion, Michigan. The defendant lives in Battle Creek, Michigan. Parties separated in late March. Since the party separation, plaintiff has spent time with the minor child. Any time that he spent with the minor child was controlled by defendant mother. Defendant mother would only allow plaintiff to spend time with the minor child if she was a supervisor and would not allow plaintiff to have the child overnight. Plaintiff is currently living with his grandparents. The home he is staying in has sufficient space for him to have the child overnight. Plaintiff has everything the child needs for him to have overnights and spend more time with the child. Plaintiff is requesting joint physical and joint legal custody of the minor child with week on, week off parenting time. The plaintiff is employed at Specialty Eye Institute as a scribe. He does travel to Jackson, Lansing, Battle Creek, and Kalamazoo for his employment. Plaintiff has worked it out with his employer that if granted equal time, he is able to leave his work early to retrieve the child from the daycare the child is in. He would ensure he would be at the daycare by 5:00 p.m. Due to defendant's controlling behavior and not allowing the plaintiff to spend consistent time with the minor child, plaintiff is in need for this court to order him to have a specific parenting time schedule. Plaintiff is requesting joint physical and joint legal custody of the minor child with equal parenting time. Thank you, Your Honor.
Thank you. Ms. Capture.
Thank you, Your Honor. Defendant has not controlled the parenting time. It is simply in the best interest of Theo to maintain his regular schedule. He's only 20 months old. Calhoun County standard parenting time schedule for a child who is from 1 year to 3 years is visits per week for 4 hours, along with one overnight. Defendant's willing to stipulate to plaintiff receiving every other weekend with a midweek visit. Plaintiff is currently residing with his elderly grandparents. They do not have the space for the minor child. There is no crib or bed for the minor child in that location. The child has never stayed overnight anywhere other than defendant's home, which is the marital residence. Furthermore, Your Honor, there's some concern that plaintiff isn't even residing in this home. The grandparents have notified defendant that he is gone for weeks on end. We have no idea where he's residing during those time periods. Again, it's in the best interest of the child to maintain a regular schedule. Taking him out of his normal home, out of his normal routine would be detrimental for the child. To avoid that, it's in the best interest that Theo have standard parenting time with dad, keep his normal schedule, and obviously split holidays. And that would also allow him to continue on a regular schedule with his nanny. Thank you.
Thank you. Mr. Vanderhorst, anything else?
Just briefly, Your Honor, plaintiff's home, he is staying in the grandparents' home. It's a 3-bedroom, 2-bath. There is sufficient space there. The plaintiff does have sleeping arrangements for the minor child, so he has everything that the minor child needs. That's all. Thank you, Your Honor.
Thank you. What the court is going to do in this matter is it is a temporary order. The court will grant the parties temporary joint legal custody. Court will grant physical custody to the defendant mother in this matter. Will grant support consistent with the child support formula and guidelines, the income of the parties. The court would grant to the plaintiff the standard alternating weekend, one half the basically alternating holidays, et cetera. And I'm not going to again include the one half the summer at this time. The child is just too young at this particular point, although the court would allow the the plaintiff to have 2 non-consecutive weeks during the summer where he could have the child upon providing the defendant with at least 21 days notice as to those particular weeks. And we'll ask Mr. Vanderhorst that you would prepare that order and submit it pursuant to a 7-day notice of entry.
I will, Your Honor. Thank you.
Court will end this matter at 9:40 on behalf of the defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Reed.
Thank you, Your Honor. The parties share one minor child, Faye, who is 9 years old. Since the minor child has been born, the parties have shared legal custody and decision-making, and my client has had parenting time on every weekend but the 3rd weekend of the month, the alternated weeks during the summer. We have severe concerns as a witness came forward that was a prior significant other of the defendant who had lived with the defendant recently, letting my client know that the defendant is abusing her medications, pain medications, as well as alcohol, and the minor child is required to take care of the defendant as well as herself, and that this individual had concerns that all of the minor child's belongings were abandoned essentially at his home and not returned to the child. And he had severe concerns regarding the defendant's ability to take care of this child now that he was no longer there. And my client shares those concerns, and now that he's been brought and made aware of those. We also have severe concerns regarding the child's schooling, as there have been many truancy letters indicating multiple absences or tardies that is starting to affect the minor child's grades. She is going into the 4th grade next year, and right now she's currently reading at a 1st grade reading level. And my client had been aware of some of these drug and alcohol issues, as a couple of years ago, the defendant's sister again brought it to my client's attention that she had concerns regarding the defendant abusing her medications as well as alcohol. But he was assured that, she stopped one medication in particular called Lyrica, which is a pain pill, and that they thought that might have been an interaction issue, but things had worked out. But now we believe she's back on that medication, is continuing to cause these problems. So we're requesting sole legal custody, sole physical custody, drug and alcohol assessment, psychological assessments. And we're also requesting that a temporary parenting time schedule be implemented, as since the defendant was served with our motion and complaint, she has cut off practically all communication between my client and the minor child. He's talked to her maybe once on the phone in the last month, and the defendant had went to the school and informed the school that my client was essentially to have no contact with his daughter, and the school wasn't to give him any information, and the police were there when he went to go pick her up for her parenting time. So we have severe concerns regarding this child and the care of the defendant, and we also have concerns regarding her ability to foster a relationship between my client and his daughter. Now, with regard to the response that we received, my client does have a valid driver's license. My client did participate in counseling once he was in that severe accident, because it did result in the death of an individual, and I do believe that was appropriate. But he does not have any psychological issues that would affect his ability to be a parent. He doesn't have any physical issues that affect his ability to be a parent, and we're trying to look out for the best interests of Faye. And my client's also requesting that the parties use our family wizard to communicate so there's no misunderstandings, and that has that shared calendar portion so everyone's up to date with doctor's appointments. Because I know some of the concerns with the absences was there were doctor's appointments that were scheduled during school that my client wasn't necessarily aware of. But that does not excuse all of the absences that were recorded or the tardies that were recorded for Faye. And I'm also requesting that the court take into consideration that my client has another child named Elizabeth, and that what the parties have been doing is trying to match as closely as possible the two girls' parenting time schedules with Izzy's parenting time schedule and my client's judgment of divorce, so that relationship is still preserved with the two girls.
Okay. Anything else?
I'm looking, Your Honor. Just one more with regard that this is essentially retaliation for a missed daddy-daughter dance. Our complaint and motion was filed before that daddy-daughter dance and before my client even knew that it was happening. So this is not a retaliatory act. This is purely concern for this child's well-being. And the other concern we have is if this child's being put in a place that she has to pick between dad and the defendant's new husband, that shouldn't be happening. It shouldn't be an either or, pick one, because I don't think that's appropriate for a child to have that mental strain and duress to have to be picking between someone that her mom married and her actual dad to go to these events. I don't see why both parties couldn't go.
Okay. Mr. Todd, I have reviewed your answer. Anything else?
Your Honor, I guess I would like to reiterate that the status quo of the parties since birth has been that my client has had sole legal and sole physical custody. Mr. Wheeler's parenting time has never exceeded every other weekend. They bring up various allegations about substance abuse. We do admit Ms. Morley had an OWI in 2018. However, that is honestly very minuscule in comparison to the extensive criminal history of Mr. Wheeler. Mr. Wheeler has 5 assaultive convictions. Additionally, we attached the diagnosis where he is diagnosed as bipolar and has anger management issues. They have no verification whatsoever of anything that they're saying. It's simply allegations where we actually have proof. In relation to the allegation that we are the ones who are making the child choose between my client's new husband and the plaintiff, that's not accurate at all. It's quite the opposite. The child chose to have my client's husband go to the daddy-daughter dance. That was purely her choice. And as a result of that, the plaintiff has threatened bodily harm to my client as well as the child. The child is doing fine in terms of school. The child's skill level is doing fine. The teacher has no concern regarding the absences. And again, the status quo since birth has been nothing beyond every other weekend. We have no issue with the court ordering a psychological evaluation, and we believe that that is totally appropriate. We would respectfully request that there is a mutual psychological evaluation and substance abuse assessment. And we do believe it's appropriate that the plaintiff's parenting time be supervised until the parties can obtain that. Given Mr. Wheeler's extensive criminal history, his diagnosis of being bipolar and having anger management issues, we believe that that is appropriate at this point.
Okay, thank you. Well, what the court's going to do at this point, this is a temporary order. The court is going to grant temporary custody to the defendant mother in this matter. The court will grant to the plaintiff standard parenting time, which would match the parenting time he has with the other child. The court will order that the parties would meet at a neutral halfway point police department, so you can figure out what the I guess the police department between the two residences would be, where the parties could meet to exchange the child. The court would order that the plaintiff would provide a copy of his driver's license to defendant's attorney. Court would further order that the parties would not consume, neither party would consume alcohol or illegal drugs for 24 hours before or during their particular parenting time. And the court would order likewise that they would utilize Our Family Wizard as a means for a communication. And the court would order, as the parties have agreed, to mutual psychological evaluations, with the parties each paying 1/2 the cost of that. And I'll leave that to your motion, Ms. Reed. So I'll have you prepare that order and submit it under 7-day notice of entry.
Was that joint physical or legal custody or
No,
sole legal custody?
no, I granted custody to the defendant.
And is that drug and alcohol or psychological assessments with Dr. Haugen?
I said psychological assessments. I'm not going to address whether, you know, what they are, just psychological assessments. Dr. Haugen, if he's going to be the one, he can figure it out.
And is it alternating weeks during the summer?
Yep, I granted the standard parenting time. Okay, Ms. Reed, you can prepare the order.
Your Honor, just one question.
Sure.
Support pursuant to the formula?
Yes, support would be pursuant to the income of the parties and their the support formula.
Thank you, Your Honor.
Appearance of Mr. Sullivan. Court will in this matter, the plaintiff, Ms. Reed, on behalf of the defendant. This matter is before the court on the defendant's motion for parenting time and modification of support. And the court will note that Mr. Sullivan has filed an answer. The court has reviewed that. Have you, Ms. Reed?
Yes, Your Honor.
Okay. Anything else you'd like to add with regard to the answer or anything?
Just that we were here, I do believe, last week or the week before, because the front of the court had made an error in the child support order where the parties were flipped, was a payer and payee. And it's our position the front of the court also made an error in calculation of child support, as it did not include the entirety of plaintiff's income. And we are requesting a set parenting time schedule, as one was not contained in the initial order of alternating weeks. And if we can get to that order soon, it would be appreciated, as my client has not seen his daughter since December.
Okay, thank you. Mr. Sullivan?
Given that the court's indicated that it has reviewed the answer that we filed, I'll be brief, but the remedies or relief that's been sought by the defendant really, in essence, seek a change of the established custodial environment and a change of custody, contrary to Vredvarka and 722.27.1c, in terms of they've not alleged a change of circumstance or a proper purpose to justify that type of relief. On the other hand, I do acknowledge that 722.27a1 does provide a party with the right to seek a parenting time schedule in specific terms, unless under subsection 3, the parent is a danger to the child's physical, mental, or emotional health. So, Judge, it's our position that at most what relief the defendant would be entitled to is a hearing to determine a parenting time schedule, with the plaintiff having the right to demonstrate that the child is at risk in the custody of the defendant.
Okay. Anything else, Ms. Reed?
No, Your Honor.
Okay. Well, obviously, there's issues raised in this matter. The court does not believe that, again, there's sufficient basis pursuant to the threshold of Vredvarka for the court to, I guess, review the issue of custody. But the court will refer the matter to the referee for an evidentiary hearing on parenting time and support. And hopefully we can get that
specific schedule worked out, and that'll help assist the parties in working through these particular matters. So court will enter that order and conclude this matter at 10:06 a.m. You're free to go. Have a good day.
Your Honor, can we have a temporary schedule before that referee hearing so we can have some parenting time?
Mr. Sullivan, what's your thoughts on a temporary schedule?
We would oppose that. We believe that he's a danger to the child.
Well, let's wait the hearing then. I don't want to jump the gun and do anything premature. I know he wants parenting time, but court's going to proceed cautiously with the allegations that have been made.
Thank you, Your Honor.
Thank you. Court will note the appearance of Mr. Sullivan on behalf of the plaintiff, Ms. Bailey Hobbs on behalf of the defendant. This matter is before the court on the plaintiff's motion to hold defendant in contempt for make-up parenting time, other relief. I guess at this point, obviously, we were in court previously and addressed many of the same issues. I guess I'll ask Mr. Sullivan, have the parties agreed to a counselor in this matter yet?
We haven't. On that subject, though, I was a bit confused about the pleading filed by Ms. Hobbs, and that on May 15th, I sent the letter indicating that we would request Lori Queta for a counselor. And she indicates in her pleading a desire to have a different counselor. So I think based on that, we are between Lori Queta and the counselor that they seek to.
Okay, Ms. Hobbs, Bailey Hobbs, why would Ms. Queta not be appropriate?
Your Honor, I did not receive that correspondence. I received a proposed order, but I did not receive correspondence regarding Ms. Queta. So
okay. Did the order state utilizing Ms. Queta?
It did not.
Okay. Might go back to my original question. Why is Ms. Queta not appropriate?
Your Honor, I've not had a chance to discuss that with my client. I don't have an answer to that at this time.
Okay, what I'll do in that regard is the court would appoint Ms. Queta as the counselor unless the defendant files some specific objections as to why Ms. Queta would not be appropriate within 7 days of today's date. Do we have a GAL that we can agree upon as well, Mr. Sullivan?
We're in the same issue with that. Again, my May 15th letter indicated that we would not be satisfied with Kim Wickham given the relationship between Ms. Wickham and the defendant. And we suggested Tom Schaefer. And then in the responsive pleading, we received alternate choices, Ms. Wickham, who we would not agree with, or Steve.
Parks?
Yes.
Okay. Ms. Bailey Hobbs, obviously I'm surprised that Mr. Schaefer would agree to that, but
he did.
Yeah, is there any problem with Mr. Parks serving as the guardian ad litem?
Your Honor, that is one of the guardian ad litem that we suggested was Mr. Steve Parks.
Okay. Court would appoint Mr. Parks to serve as guardian ad litem in this particular matter. What I'm going to do as it relates to the rest of the motion is obviously we need evidentiary hearing before we can ferret these issues out. There's a lot of allegations. Court is going to order that there would be, again, if the parenting time does proceed, that there would be no alcohol consumption for 8 hours before parenting time nor during parenting time. The court would also order that the child would have access to a cell phone provided by defendant. And again, court will reserve further relief pending an evidentiary hearing in this matter. So hopefully with the assurance that there's no alcohol consumption, that will help waylay the fears of the child in this particular matter. Plus you would have access to a cell phone to talk to, again, the defendant should she need to do so. And hopefully that would remedy some of the issues, and then we'll proceed with the counseling and with Mr. Parks' investigation as well. I'll ask Mr. Sullivan that you would prepare that order and submit under 7 day.
I will. Thank you.
Okay. Thank you.
Your Honor, may I just clarify? You stated there's no alcohol 8 hours before, during, and access to a cell phone provided by defendant. Can I clarify that that's during plaintiff's parenting time?
Well, I'd be no sense to have it not being during his parenting time.
I'm just clarifying.
Okay.
There's no question.
I mean,
I understand.
okay. Okay, thank you. Mr. Sullivan, you can prepare it to Mr. Seisel on behalf of the defendant. To the plaintiff, just so I don't butcher your name, how do you pronounce it?
Ray Saborski.
Ray Saborski. Okay, I would have messed up.
I was born with that name.
Okay.
Took me a long time.
Okay. This matter is before the court on the defendant's motion for a specific parenting time. Mr. Seisel.
Good morning, Your Honor.
very briefly, some context here. So the parties have 3 minor children: Olivia, age 17, Jacqueline, age 15, and Mitchell, age 14. The parties were divorced by judgment in September of 2022. That judgment gave them both legal and physical custody of the children. Under the parenting time provision, it states as mutually agreed. However, if they couldn't agree, it set a specific schedule as a backup. Then in January of 2023, they agreed to a modified parenting time schedule in custody. Olivia, the oldest child who has special needs, defendant father was given primary physical custody of Olivia. And then Jacqueline and Mitchell, plaintiff mother, was given primary physical custody of those 2 children. With respect to parenting time, it simply says generally as mutually agreed upon by the parties, but it eliminated the backup specific schedule. So what's been happening is since November of last year, plaintiff has refused to let Jacqueline and Mitchell visit their father and has refused to work out a reasonable parenting time schedule or plan with defendants. So Mr. Lera hasn't seen his 14 and 15-year-old kids for approximately the past 6 months, Your Honor, and it's getting very close to alienation here. So the issue for the court is whether there's proper grounds to modify the current custody arrangement and order a specific parenting time schedule. Defendant obviously believes there is grounds. And so very briefly, some of the applicable legal standards. Your Honors, you know, there's a statutory presumption that it is in the best interest of the children to have a strong relationship with both parents. The frequency, type, and duration of parenting time must be reasonably calculated to promote that relationship. And the children actually have a legal right to parenting time unless it can be shown by the other party by clear and convincing evidence that parenting time would endanger the children. And here, in terms of the legal threshold to move on to a modification, because there would be no change in the established custodial environment, we think the very expansive standards set forth in Shea would apply. And here, Your Honor, defendant father's desire to have parenting time and plaintiff mother's refusal to allow it is proper grounds to now reestablish a specific parenting time schedule that was set forth in Kane, which is a Michigan Supreme Court decision, 314 Mich 529. And the Michigan Court of Appeals has actually also held that parenting time must be granted in specific terms if requested by either party at any time. And here, defendant father has requested parenting time with his 15 and 14-year-old for nearly every weekend for the past 6 months. Plaintiff has refused. Your Honor, I think your response to the motion simply illustrates the need for these parties to have a specific parenting time schedule. There's a lot of finger pointing between the parties in terms of who's at fault for defendant father not seeing his 14 and 15-year-old right now. But that to me just illustrates that we have 2 options: the status quo, where these 2 are not going to agree and defendant father has 0 parenting time with his kids, or we go back to a very specific schedule that the parties can enforce. They understand what the terms are going forward, and they can actually provide that relationship between father and these 2 children that he hasn't seen for quite some time.
Okay.
And
let me go to the defendant, or I mean plaintiff.
Yes, Your
Honor. I've reviewed your answer. Why shouldn't he have some sort of a set schedule?
I've never told him he can't see the kids. I've asked him to take the kids. Yesterday, I took the kids to his house. He had his driveway roped off and refused to come speak to them. I don't know what else to do.
Okay.
They want to see their dad. Well, Jacqueline does. Mitchell does not. Mitchell wants nothing to do with him. Jacqueline's asked him to take her after school. He's been told you can come any day, Monday through Thursday. She gets out of school at 2:00 and you can come and get her. He will not come and get her.
Would you agree that he could have what we call a standard parenting time, alternating weekends, a midweek on Wednesday, alternating holidays, et cetera, until such time as we can get a schedule in place?
I do not agree simply because, and this is the only reason why I do not agree with changing the overnight schedule, because he has told the courts he does not want an overnight schedule. The children are not welcome there. And then he has made it very clear on the numerous occasions I brought the children to him that they are not welcome around him or his wife. They no longer have bedrooms at his house. He has a roommate living in their kids' rooms now. They don't have anywhere to sleep. He's made it clear to Jacqueline this weekend. She called into work on Saturday because she is afraid of him. He called her Thursday night and threatened her. And I don't know what else to do. I want them to see their dad.
Okay. And that's what we're trying to do on the interim, is to work something out where he could see them until such time as we can have a hearing and, ferret everything out. So I was simply asking if we could do the standard alternating weekend, Wednesday midweek. If he doesn't take advantage of it, he doesn't take advantage of it. That's all we can say. And obviously that will come in play at the evidentiary hearing.
I am 100% in favor of him taking those kids any day of the week for dinner. They get out of school at 2 p.m. They're almost done with school, actually. They'll be done next Wednesday. I am 100%, and I have told him this. I have texted him this. The kids have texted him this. He is more than welcome to come and get them from at 2 o'clock when they get out of school. I don't even get out of work until 5. So it's not like I'm doing anything with them from 2 until 5. If that doesn't work based on his work schedule, please just have them home between 8 and 9 if they have school the following morning. I've asked for this since November. They've asked for Christmas cards. They've asked for birthday cards.
Okay, let's do this. Is in the interim, court is going to refer the matter to the referee for an evidentiary hearing on the issues of parenting time. But up until that time, the court will implement a standard parenting time, which is alternating weekends, Friday to Sunday, midweek, alternating holidays. I'm not going to put in place a summer parenting time at this point till the referee can address that at the time of the evidence.
Your Honor?
Yes.
The kids don't have anywhere to sleep at Stephen's house.
Well, he'll have to provide them a place to sleep or he won't be able to keep them over the night then.
And Mitchell won't go on his property because of the animals. Mitchell's terrified of his dog. He's been attacked. He won't go.
No, I don't need any testimony from you, sir. You have an attorney. The attorney will, that's what's going to be the interim order in this matter. And then we'll see what happens. And you can get in and you can present all of the evidence at the referee hearing. So Mr. Seisel, I ask that you would prepare that order, submit under a 7-day notice of entry, and the court will do a referral order to the referee on parenting time.
Yes, Your Honor.
We'll conclude this matter at 10:33 a.m. You're free to go. On behalf of the plaintiff, defendant appearing in pro per, this matter is before the court on the defendant's motion to set aside the referee recommended order. Mr. Smith, you can't simply, again, change it just because you don't like the results. And I know that appears that there's various issues that you've brought up, but you're going to have to establish that the referee made a legal or factual error in this matter. So what is the legal or factual error that the referee made?
The referee set my parents as supervisors without establishing whether my parents were able or willing to do so.
Okay.
That is the biggest issue.
Okay. And they're not able to do so. Is that correct?
They're not able to, no.
Okay. So that's the main issue is the supervisors.
The biggest issue is the supervised visits, yes, because the supervisors are not willing or able to do it due to the fact that they like to go camping through the summer. So most weekends, plus sometimes throughout the week in the summer, they're gone camping. And Mason has requested me to try to get the supervised visits gone because he feels he's not getting enough time or able to spend good time with me because we're stuck doing everything else.
Well, I'm not going to change that part of it. I mean, you haven't established any factual or legal error. Obviously, the factual dispute is the fact the supervisors. What the court is going to do is I'm going to give the parties an opportunity. I'll give you 21 days to come to an agreement as to alternate supervisors. And if you can't come to an agreement in that time, then Mr. Smith, you'll submit a name of 3 individuals that can supervise the parenting time. And Ms. Corp, you'll submit 3 names as well. And then the court will address whatever complaints each of you have with those 3 particular individuals. And if you can't agree, then court will address it and the court will set an additional supervisor in this matter. So Ms. Corp, I guess I'll ask that you would prepare that order so that we make sure that we get an order to that effect that says parties will agree within 21 days. If not, they would submit a list of 3 individuals that could supervise the parenting time. And they would, in fact, give specific reasons as to why the other parties' supervisors wouldn't be appropriate.
Okay. And then just note that either party can schedule a hearing?
Yes.
Okay. All right. We'll do, Your Honor. Thank you.
Okay. Thank you. Note, court will in this matter at both of the parties as well as Mr. Horton, the alleged father in this matter. This matter is before the court on the plaintiff's motion by the presumed father to determine child born out of wedlock. In this matter, I guess I'll ask you, Mr. Corral, have there been any genetic testing done at this point?
No, there hasn't been at this point that I know of. I don't believe I haven't done any.
Okay. Mr. Wharton, have you done any genetic testing?
No, sir, there was never a need to. He wasn't in the picture at all from the point we met. They'd already split up and were long over at that point. And then we didn't have kids for another 6-7 years after that.
Okay. Well, what I'm going to do is we don't take testimony on motion hearings. As you know, we've got a lot of hearings and we wouldn't have the time to do that. We'll set, based upon what you said, court will set this matter for a Wednesday evidentiary hearing. And we'll take some testimony at that time. Would you all be available for next Wednesday, June 7th at 1:30?
I should be.
Okay. Ms. Correll, how about you?
Yes, sir.
And Mr. Wharton?
Yes, sir. I'm available.
Okay. We'll set it for next Wednesday, June 7th. at
DS
1:30
Marissa De Leon versus Darmian Newsom, attorney Allison Greenlee Court for defendants.
Okay. Good afternoon to both of you.
Hello.
I'll start off with you, Ms. Deline, because you are the plaintiff.
Mhm.
What issues do you believe to be in dispute in your case?
What do you mean by that? Sorry.
Well, what are you fighting about?
Just having financial support from him, from Damian Newsom.
Okay. Are there any issues concerning custody or parenting time that you're aware of?
No, I know he has stated that he feels that I keep Eli from him, but this is what we have done for the last few years and it's worked for us so far. I'm not trying to take really anything from him necessarily. I would just asking for financial support.
Okay. Let me ask Ms. Greenlee-Clore, what issues do you believe are in dispute?
Just like most cases that are filed, they're DS cases, there's a contested custody, parenting time, and child support issues.
Okay.
No paternity.
Where are you at as far as, have you done any discovery? Do you need any discovery? What's that issue?
I think the only discovery we might need would be income information from either party.
Okay. Well, it shouldn't take long. We'll give you 30 days and have July 1 as the discovery cutoff date.
Sure.
Ms. Deline, what that means in this matter is you have until July 1 to acquire any information you need from the defendant, okay?
Okay, what does that mean? Like with me finding out how much he makes and
Getting any information from him. So doesn't just pertain to that, anything. You can do it through interrogatories, which are questions submitted to him that he has to file under oath. You can do it through request for production of documents. You can do it for depositions or anything else that you could subpoena. You can do that, but you have to do it by July 1, okay?
Okay, so I can't just physically talk to him about it.
Well, you can talk to him all you want. I'm just saying if you have until that date. So if he doesn't respond or whatever, you have until that date to get things done.
Okay.
I don't assume, ma'am, that you are aware of any of the mediators. So I guess I'll ask Ms. Greenlee-Clore, who would you like as a mediator in this case?
I'd like to use Michelle Woznicki. I think she's affordable and does a really good job.
Okay. Ms. Deline, do you have any problem with Ms. Woznicki?
So does that entitle like me having to pay for?
You will have to, when it's in mediation, you have to pay for the mediator because it's an attorney mediator. So you would be responsible for 1/2 the cost.
Okay.
Yeah, Marissa, if we reach an agreement ahead of time, we don't have to go to mediation.
Okay. Because my main complaint is just financial help. I would like to really avoid, obviously, extra fees and things.
Okay. I forgot. What's Ms. Woznicki's first name again?
Michelle, it's with an E. Michelle, looks like.
Okay. I knew there was something different and
Yeah.
I couldn't remember.
Yeah.
That mediation will take place in July. So we'll set August 7, 2022 at 1:30 p.m. as the date for the settlement conference.
When was that, Judge? I'm sorry, could you say it again?
August 7th at 1:30 p.m. It will be in the order.
Thank you.
In order, all the stuff we're talking about here today, you'll get an order that'll state all of this.
Okay.
I will let you know that in that order, there's dates that you have to comply with that have consequences if you don't comply. So make sure you read that because there's like dates for disclosure of witnesses and exhibits and that. And if you don't do that and you come to trial, let's say you don't settle it, you come to trial, you're not going to be able to maybe have any witnesses testify or you won't be able to have any exhibits if you don't comply with the order. Okay.
Okay. And then I did have a question. I received different paperwork when Damian had, I don't know, his statements against me or agreeing to, and it had a date of June 5th, I believe. Is that still a court date that I have to go to? Because Because then I got this paperwork for this court date after that paperwork.
I don't know what the June 5th date is, so I don't have that in front of me at this point.
Okay.
Ms. Greenlee-Clore, are you aware of anything on June 5th?
I'm looking here. There is a motion hearing on June 5th. Yes.
Okay. On that motion hearing, you do have to appear at that date unless the motion is called off for some reason.
Okay. What does that exactly mean for the motion?
Well, I don't have the motion. I don't get those until tomorrow, so I don't have any idea what the motion is.
Okay.
So it's just a motion hearing. You'll appear by Zoom, just like you're doing here.
Mhm.
And whatever it is, let's say let's say it was a motion for exclusive possession of the house. And he's asking for exclusive possession. I don't know what he's asking for because
Oh, okay.
I haven't seen it, but whatever he's asking for, you'll have to respond and, state why he shouldn't get what he wants or why he's not entitled to. I don't know. Whatever you want to respond, you
Okay.
can respond.
Okay.
Okay. And make sure that you send a copy to Ms. Greenlee-Clore too.
Okay.
Anything else you have any questions, Ms. Deline, or anything else that I can help you with?
No, I guess I'm just kind of going through this kind of blind too.
Ms. Greenlee-Clore, anything else that you're aware of?
No, Judge. Thank you.
Okay. Thank you. And we'll end this matter at 1:29 p.m. You're free to go. Have a good day.
Thank you.